So, good afternoon. It gives me great pleasure to open and chair the 2023 Lionel Cohen Lecture, to be delivered by Professor Richard Susskind. The Lionel Cohen Lecture is perhaps the Faculty of Law's most important and prestigious annual lecture. Certainly the oldest. The first lecture was delivered in 1953, close to the graduation of the first class of the law faculty. Ever since, almost consecutively, the lecture has been delivered by a leading jurist from the United Kingdom, or a Commonwealth country at least. And the list of Lionel Cohen addresses includes a very impressive collection of lords and barristers, and we're delighted that Professor Susskind will be joining this list today. The Lionel Cohen Lecture marks the unique relations between the British and the Israeli judiciaries and legal communities in general. And while these relations go back to the common law system or common law tradition, which is a major basis of the Israeli legal system, in today's complex times, the relations span many other areas of common interest, such as the topic of today's lecture, artificial intelligence and the law. Just by way of background, Lord Lionel Cohen was born in 1888. In 1943, during the Second World War, he was appointed as a judge in the High Court. He then was appointed to the Court of Appeal, and in 1951, he was appointed a law lord entering the House of Lords, where he served until his retirement in 1961. Cohen chaired many royal commissions in the years following the Second World War, particularly in the areas of company law and compensation. From 1946 to 1956, he chaired the Royal Commission on Awards to Inventors, which acknowledged scientists who had made technological advances. So how fitting then that today's lecture's topic is on law and technology. And the trustee of the Lionel Cohen Lecture Fund is currently Lionel Cohen's grandson, Sir Jonathan Cohen, KC, himself a High Court judge, and the Faculty of Law is extremely grateful for the continued support of the Cohen family. A few words about our distinguished speaker, Professor Richard Susskind. Professor Susskind is a global thought leader on technology and the law, having written already in the early 1980s a PhD dissertation at the University of Oxford in law and computers on the topic of artificial intelligence, right? Yeah. Since then, he has authored numerous influential books, including The End of Lawyers, with a question mark, so not everyone has to be concerned. That's from 2008, and Online Courts and the Future of Justice from 2019, and has also expanded his interest beyond the impact of technology on the law and the legal profession to its influence on other professions in a book co-authored with his son, which must have been quite an experience, The Future of the Professions, How Technology Will Transform the Work of Human Experts, from 2015. And Professor Susskind is a frequent consultant on information technology and the law, including to the Lord Chief Justice of England and Wales, Lord Burnett, a previous speaker in the Lionel Cohen lecture series. And I'm very grateful that Professor Susskind has been able to accept our invitation at relatively short notice, and to the British Friends of the Hebrew University for facilitating his visit. And the lecture will be followed by time for questions and answers. So Richard, the floor is yours.
Thank you, Dean, for that very kind invitation. It's a huge pleasure to be here today. It's a particular pleasure for me because I've known of this series of lectures for over 40 years. When I was a law student in Glasgow University, and still today, my favorite legal author was Herbert Hart, H.L.A. Hart. And I saw this book. It must have been 1979, first of all. And I remember thinking, Lionel Cohen lectures, I wonder what they are. And I now know what they are, and it's a huge pleasure to be giving one today. What I thought I'd do is organize my comments under these headings. I want to talk about the mindset I think we need to have in the legal world in thinking about the future. I'll then briefly suggest to you there are three main drivers of change in law. Indeed, I think we're in the middle of a period of about 2 decades where we'll see more change in the way law is practiced and justice is administered than we've seen in the past 2 centuries. One of these drivers is technology, and I want to give you a sense of how technology is affecting the way we live and labour. That will take me to the heart of the presentation, which is on artificial intelligence. Artificial intelligence I will deal with in some depth, giving you a sense, a historical sense, I hope, of how its use has changed across the legal world over the past few decades. This will lead naturally, I think, to a discussion about what jobs there will be in the future in a world where there are more and more advanced systems. And finally, and with some hesitation, because I do think we're at a period of remarkable change, but I will make some predictions about what we might see in the second half of this century, or rather the second quarter of this century. Isn't it remarkable, though, that we already are coming towards the end of the first quarter of the 21st century? So let me discuss, first of all, mindset. One of my favorite stories in life is about Black & Decker, who manufacture power tools. And it's said when they recruit new executives, they take them off on a course, they sit them down in a room much like this, and they put up a slide, much like the slide before you. And they say to the assembled new executives, "This is what we sell, isn't it?" And the new executives look rather surprised by this. They say, "Of course that's what we sell. We're Black & Decker, we're the world's leading manufacturers of power tools." Well, the trainers with some satisfaction then say, "That's not actually what we sell, because this is not actually what our customers want. This is what our customers want. And it's your job to find ever more creative, imaginative, competitive ways of giving our customers what they want." There's a very profound lesson here, I think, for everyone working in law. When we think of the future, and I've already had the opportunity to have 2 conversations this morning with 2 groups, the tendency always, and was in the rooms this morning, the tendency is to think of how we do things today and how we can improve a bit upon them. How can we make that power drill a bit cheaper, a bit quicker, a bit lighter? But I say, as we move into an ever more digitalized world, that we need a rather different attitude. We need to ask ourselves, in whatever area of law in which you work, what's the fundamental value we bring to those we serve? And might we bring that value in a different way as technology becomes more advanced? So I'm asking you not simply to think of the power tool and improving upon it. I'm asking you to take that step back and ask about the fundamental value you bring, whether as an educator, whether as a practicing lawyer, whether as a judge, whether as a public servant. That's one thought by way of mindset. A second has to do with technology. I draw a distinction, and always have done, between automation and innovation. I'm not sure innovation is the right term from what I'm about to explain. I don't actually think there is a term for it yet. But automation we're all pretty clear on. It's what most people think of when they think of technology. You take some kind of task or system or process or activity, often inefficient today, and you computerize it. You systematize it. You streamline it. You optimize it. You turbocharge it. The fundamental point here is that we think of automation as applying technology to something that already goes on. And indeed, the first 65, 70 odd years of legal technology and court technology have been devoted precisely to that, to grafting technology on to how we've always worked. And of course, that will drive out some efficiencies. But if you look across the world at the really game-changing uses of technology, not just in law, but elsewhere, the systems and services that have transformed the way often we socialize, say over the last 20 years or so, the various tools we use, the game changers are rarely examples of automation. Almost always they're instances of what I call innovation, by which I'm meaning very specifically the use of technology to allow us to do things that previously weren't possible. That, for me, is the great excitement of technology. Not simply automating what we've already done in the past, but in using the power of existing and emerging technologies to allow us to work entirely differently. For example, to allow us to crack the access to justice problem globally, which will not be solved, in my view, simply by throwing more lawyers and judges. We need radically new thinking enabled by these very powerful technologies. So I'm asking you to think not just about the hole in the wall, but also about innovating as well as automating. And finally, I ask you to try and look ahead as well. Who's this? His name's Wayne Gretzky, said to be the finest ice hockey player of all time. When asked once, why are you such a great ice hockey player? He says, it's because I skate to where the puck is going to end up, rather than where it once was. So he shares with so many great sports people that great sense of anticipation, but he also shares it with great business people who somehow have a sense of where the market is going to end up. And what we have to do when we're thinking about the future today, suffused as we all are with enthusiasm about, for example, generative AI and ChatGPT, on which more soon, but that's not where the puck is going to end up. That's where we are today. We need not, or should try not to be technologically myopic, to evaluate the future in terms of current technologies. What I want to give you a sense today is of how rapidly these technologies advance and how what we have today puts us very much in the foothills. So what are these drivers of change I talk about in the legal world? Their cost, competition, and technology itself. Cost, whether or not you are the general counsel, the top lawyer in a major international corporation, or an individual consumer and citizen, for almost everyone, legal services are becoming unaffordable. General counsel say to me they're under pressure to spend less on external law firms. They're under pressure to reduce their internal legal teams. And yet, and this is vital, they have more legal and compliance work to do than ever before. I first detected this more for less challenge in work I did for a Magic Circle firm, one of the leading firms in London, in 2004, where it became very clear that the budgets in major organizations for law were going to be limited. Now this, of course, was exacerbated through the financial crisis, through COVID, and now because of the Ukraine war. But we have to anticipate, even in the biggest companies, that there'll be less to spend on legal work. And as I say, the access to justice problem for most is a problem of unaffordability, that people simply don't have the cash to retain lawyers and go through the court system. So cost, a pressure and cost, is going to define, and it's not glamorous, it's not sophisticated, it's terribly simple. It's going to define the next 10 years of legal service, how lawyers working with the community can find ways of delivering more legal service at less cost. The second very interesting factor, as a commentator and observer of the legal world, is the advent to the legal ecosystem of new players. At one end, you have the big four accounting firms. They look at the global market for legal services, almost $1 trillion. They see there's a level of dissatisfaction amongst many traditional users of these services, and they think there's a huge market opportunity for them. They're credible at board level, they have experience of new labor models, they have different ways of using technology, and they are and will be quite aggressively coming into the legal market, which I think is good for clients, offering more choice. And I think it's healthy for existing law firms too, encouraging them to modernize and improve. But the competition doesn't end there. At the other end of the market, if I may put it that way, you have the legal technology startups. There are about 3,000 to 4,000 of these small businesses around the world. And according to my research, about a quarter to a third, about 1,000 of these are trying to do to law what Amazon did to book selling. These people are not there to support and enhance traditional ways of working. They're trying to find ways of disrupting the legal marketplace, of offering cheaper, better, quicker legal service more conveniently, of bypassing the court system, offering new ways of delivering court service, developing tools also to help people avoid getting into legal problems in the first place. And while most of these law tech startup companies will fail, as is the way of all startups, a few, in my view, will emerge and fundamentally change the landscape. So there are going to be huge pressures and costs. There's going to be new competition. But in the long run, it's technology, the focal point of this lecture, that in my view will exert the greatest influence on the evolution of the legal market and in the evolution of law itself. So let me, before I dip down into artificial intelligence, say a little about technology itself. I'm half a lawyer and half a technologist. And as a technologist, we all have different ways of explaining what's going on in the world of technology. I like to do so under 4 headings. My first observation, and if I may give you the only takeaway you need to have from this lecture, is this, that our systems are becoming increasingly capable. Notice this doesn't mention AI, metaverse, blockchain. Put all of these to one side. I will return to some. But the fundamental point about the computer systems we're developing around the world is they're becoming increasingly capable. Hardly a day passes that we don't hear news of some new system or breakthrough or startup or app. We're hearing news of systems frequently now that are taking on tasks that in the past we only thought could be undertaken by human beings. Our systems are becoming increasingly capable and at an almost unfathomable pace. I'll talk about AI in a second, but let me just sidestep to another technology to give a flavor. Affective computing. Machines that can both detect and express human emotions. A system that can look at your face and tell, indeed, whether or not you're happy, surprised, angry, or disgusted. There's a system now more accurately than any human being can listen to 2 female voices and tell whether or not they belong to a mother and a daughter. There's a system more accurately than any human being can look at a human smile and tell whether or not that smile is fake or genuine. We often say as lawyers, we pride ourselves in reading the room. We say our empathy is important. We say we engage, we resonate, we can recognize the emotional state of those we advise. This may or may not be true, but I'm very confident within the next decade or so, machines will outperform us in being able to detect the emotional state of those we advise. It's going the other way as well. And I want to preface this by saying I don't take what I'm about to talk about entirely seriously, but it is worth listening to. I bring you news from the outside world of the Huggybot. And the Huggybot's a robot that will scan your face to determine your emotional state. And then in terms of duration and intensity, will give you just the right hug for the occasion. And serious empirical research has shown that, and I find this remarkable myself, more people prefer a hug from a Huggybot than they do from another human being. Do not take it seriously as a case study, but do expect that we will be receiving emotional signals from our machines. They will be giving us comfort. They will be emotionally engaging with us. It's just one of many respects in which our machines are becoming increasingly capable. Now, more technologically, the underpinning technologies in our world are growing at an exponential, explosive rate. We'll all have heard of Moore's law about the doubling of processing power every 18 months or so. But whether it be processing power or hard disk capacity or bandwidth or memory, we're seeing remarkable explosive growth. I like the little example of the card you put in your camera, perhaps. 2005, 128 megabytes, 2014, 128 gigabytes, more than a 1,000-fold increase in that period. And of course, we're now into the 2 terabyte era. It's just a different concept altogether. We're seeing this remarkable explosive growth. But this is happening over the years. Think of neural networks, the technology that underpins machine learning, that underpins the language models, the ChatGPT-like systems we're hearing so much of. This technology, the performance of neural nets, is doubling every 3.5 months. That means that over the period of the next 6 years, it will increase 300,000-fold. So you can sit there at ChatGPT and think this is amazing. Honestly, folks, we have no sense of what's coming next. There's no finishing line. No one in China or South Korea or Silicon Valley or indeed Israel is saying job done with technology. Let's plateau for a while or pause. Quite the reverse. the scale of financial and intellectual capital being devoted to technological advance is unprecedented. We live at a time of greater technological advance than humanity has ever witnessed. It's happening on our watch. So many definitive decisions about the future of humanity and our fundamental institutions will be made over the next couple of decades. And there's no finishing line. Which leads me to my final observation when I'm putting technology in context. And this I find at once both exhilarating and terrifying. I'm talking about the not yet invented systems. In the grand arc of human history, what we've got so far and have developed over the last 70 years or so in computer technology will be pitiful in retrospect in, say, 100 years' time. I believe by 2030, our lives will have been transformed by technologies that have not yet been invented. But we are, as I say, very much at the foothills, at this period of remarkable technological change. And I'm looking 25 years ahead today, but if you look, say, 200 or 300 years ahead, we'll be looking at an entirely different construct of planet. I can't overstate this enough. Our systems are becoming increasingly capable. The underpinning technologies are growing at an exponential rate. There is no finishing line, and the best is yet to come in terms of sophistication of systems. Now, any lawyer, if I stopped the lecture now, who would say, well, that doesn't apply to me, and it's quite a lot of lawyers who think that, I think is deluded. And my career has been devoted to saying, raising a flag saying, within my lifetime, with any luck, we're going to see fundamental change. So let's turn to artificial intelligence. As the Dean said in his introduction, I wrote my PhD on AI and law in Oxford in the 1980s. So this is what I've spent most of my life thinking about. I want to tell you a little bit about my story and the story of others in these early stages to give you a flavor of where AI and law is coming from, because I think that will help us to plot a future. But I want to say something immediately, perhaps to reassure and perhaps just to put in context, that I think almost all the short-term predictions being made about AI, even in light of generative AI and ChatGPT, I think almost all of them hugely overstate its short-term impact. However, and far more fundamentally, I think almost all the long-term predictions that are being made about AI and law hugely understate its impact. Will AI and law, or will AI change the law and legal processes and the legal landscape fundamentally over the next 2 years? Absolutely not. Some of the technology might be there, but for cultural, regulatory, commercial reasons, we won't see a movement at that pace. By 2030, I say confidently yes. This is my 5th decade of working on AI and law, and I've only felt able to say that. This will be the decade during which AI will play a fundamental role, but still an early role in the transformation of law and legal institutions. But let's go on a little bit of time travel now. I want to take you back to before I was born in 1960, the first National Law and Electronics Conference in California, October 1960. Reed Lawler said this: "The day should come when you will be able to feed a set of facts to a machine that has cases, rules of law, and reasoning rules stored in it, and in which the machine can then lay out for you, step by step, the reasoning process by which you may be able to arrive at a conclusion. You can study it and then decide whether the machine is right or wrong. In some cases, the machine may not tell you exactly what the solution may be, but may say there is a probability that such and such is correct, and this probability is 90%. This statement came out just 4 years after the legendary meeting at Dartmouth College of the people who invented the term artificial intelligence. So this is very early days, and if this vision was realized, and I'll explain in a few minutes, a couple of decades after this. But this is the first, I think, articulate statement of what AI might do in the law that I've found in the literature. And then 2 fundamental articles were published in the 1970s in Stanford Law Review in 1970 by Buchanan and Hedrick, where they speculated about artificial intelligence and legal reasoning, still a great article. And a man called Thorne McCarthy, often credited to being the father of AI and law, in 1977, wrote a very sophisticated article in the Harvard Law Review. So in the 70s, there was some theoretical work building up Now, I entered the fray as a law student. I was studying in Glasgow University in Scotland and got interested in this in 1981, and this was my undergraduate thesis. Now, those of you who are over 50 will know that we didn't have printers at that time that could print large typeface. So you used something called letraset, which is essentially transfers and stickers. And I still am embarrassed that I couldn't even put the transfer on straight, that it's at a wonky line, as we say. But nonetheless, this was the piece of work I did. I called it an essay in applied jurisprudence. And it was then that I became aware of the field in AI and law. And the quotation in the front was the quotation that I read out to you just a couple of minutes ago. I then went to Oxford and wrote this doctorate on AI and law at Balliol College in Oxford, finished in 1986. And I looked at, in that context, what I will explain to you in a second is the first wave of AI, expert systems and law. And my basic thesis was this. I was looking at it from a point of view of legal philosophy, from a point of view of jurisprudence. I was trying to explore the limitations and implications of computer systems that could solve legal problems. What did this mean for our theorizing about the law, and how could our theorizing about the law help us design and develop these systems? So I tried to identify, for these legal philosophers in the room, and I know there's at least one, if there was consensus in the field of analytical jurisprudence, which would help me as a potential architect of these new systems. I built what was called a rule-based deductive model, and it was inspired largely by four writers. And I didn't just put this in because Hart was one of the previous Lionel Cohen lecturers. This is a slide I've used before, and Herbert Hart was my main influence, but also Joseph Raz, born in Israel, a man called Jim Harris, another called Hans Kelsen. And they helped me design a system that I felt was robust from a theoretical point of view. And that little mystical phrase at the end there, clear cases of the expert domain, I identified the limitations of the systems I had in mind, that they would be able to solve problems, if I can put it more crudely, problems that legal experts found easy, but the rest of us found hopelessly difficult. That was the fundamental contribution I made. My area of application, my domain of application was family law, the Divorce Scotland Act 1976, together with case law, which was reduced to a formalism. And then I published it as my first book in 1987. But I wasn't the only person who was working in this tradition. And most notably at Imperial College in London, a group of scholars and friends had quite imaginatively translated the British Nationality Act into a logic program using the software Prolog. We were all, as we came together for the first international conference on AI and law, and this was in 1987, we were all thinking about how we would move this stuff from the research laboratory into the marketplace. And that then leads on to what I want to discuss with you, which is the first generation of AI in law systems. And we'll get to the second generation shortly. The first generation were these rule-based expert systems. But I'd like to tell the story of this. The story lasted for 2 years, from 86 to 88. And it started with a man who became a very close friend of mine called Philip Capper, who had been the chair of the law school when I'd been at Oxford. He'd been one of my examiners at one stage. And he came to me with this book he'd written called Latent Damage Act 1986. And that was a new piece of legislation, a very complex piece of legislation. And I'd like you to read the following extract from it. Section 2 of this act shall not apply to an action to which this section applies. Now, English is my first language, and I don't understand that. Philip, in his book, described it as a dense web of barely intelligible interrelated rules. This was an area of law that fundamentally affected the manufacturing industries, the construction industries, the professional services industries too. It related to the law of limitation, to the all-important question, when can an action no longer be raised in the courts because too much time has passed? In England, we call that when an action is time-barred. And with this new legislation, finding an answer to that question seemed, even for expert lawyers, almost impossible. So Philip said to me, why don't we do or use the research and the findings from the research that you did for your DPhil, why don't we use that and build a system? I'll be the domain expert. That's the person from whom, in expert systems language, we elicited the knowledge. I was the knowledge engineer, the person who sat down and mined the jewels from his head. and we represented his knowledge in a system. This was the front screen of the system, and I want to assure you in the late 80s this was regarded, certainly by us, as cool. It's now slightly, frankly, embarrassing, but it's at the time we were very pleased with that use of clip art. This, you have to remember, was in an era where floppy disks genuinely were floppy. The web had not been invented. The system we developed, you couldn't say go online. There was no online to which to go. And we had these daft floppy disks that we had to distribute the system on. The system itself was like a decision tree, a flowchart, but a really complicated one. There were more than 2 million paths through this system that we developed. This is how you developed an AI system in the 80s. You handcrafted it. You sat down with a human expert, you analyzed their expertise, and you developed the mother of all flowcharts. It wouldn't have fitted in that wall. It was just massive, hugely complex. But that, I think, gives an indication that the intelligence lay not so much in the system, but in the pre-processing, the engineering, the work we did beforehand. And then we essentially plopped the decision tree into the system that allowed other people to navigate around. We made sense of this complex roadmap. In operation, it actually talked a little bit like a lawyer. I want to give a flavor, and you don't need to dwell, but I just want you to know what it looked and felt like. So, first of all, no graphical user interface. Looking at the age of most of you in this room, you probably don't know what I'm talking about. There was a time when you didn't use a mouse. There was a time when it was just bold, boring text like this. And so it starts off saying, this wasn't quite the first screen, there were but 3 screens trying to limit our liability for any loss, damage, or injury that would flow. But here's one of the first substantive screens. No area of law is self-contained. This system focuses principally on negligence liabilities and related aspects of contract, product liability, personal injuries, and fraud. Does your case fall within these categories? So see, clearly you need to be a lawyer to use the system. It was an expert system for a lawyer. We called them expert system for a lawyer to make he or she more expert. And then another example, a central element of the law on latent damage is that knowledge about the loss, damage, or injury, or about the defendant responsible for it, it's really sounding like a lawyer, arises only sometime after its occurrence. Does this element seem to be present in your case? Yes or no? In every response, you're pruning away a little bit of the tree. From what you've said so far, it seems that the most likely basis for alleging liability will be tortious negligence. Shall we proceed on that basis? If you say no there, it goes on to proceed in terms of contractual negligence or simple breach of contract. Did the defendant's role, this extract I've taken from was about a building, did the defendant's role in design or construction continue until completion of the projects? Trying to get some sense of the involvement of the parties and when they were involved, and on you go. 10 minutes later, summary of consultation. In your case, the limitation period applicable by virtue of Section 14A4 of the Limitation Act 1980, introduced by Section 1 of the Latent Damage Act 1986, etc., is the later of 6 years from, or 3 years later, and so forth. On it goes, and here we go. According to the legislation and case law in the system, the last date on which proceedings could be started in your case is 21st December 2012. Now this is it, folks. This is a system that takes this unbelievably complicated area of law and gives you a concrete, definitive answer based on the best expert in the world, 35 years ago. So that was the first generation of AI. Did more than that, though. In contrast with what I'm about to talk about in the machine learning systems, it offered an explanation of its lines of reasoning. It told you all the fundamental dates on which it relied. So that was the book that Philip and I wrote, and it was probably the best fun I've ever had. And he agrees too, developing that system was just great fun. In terms of its performance, I should say to you that he would say to this day that it was better than him, and he was the leading expert. And the other interesting thing, and this foreshadowed, oh my goodness, what we're seeing so much of today, is that the system surprised him. Quite often they'll say the answer is 5th of August, whenever, and you say, that's not right, and you say, no, it is right. And these systems often do things that are beyond the contemplation of those who designed it. And that really is a running theme of the machines we're developing today. We presented that at the second International Conference for AI and Law in '89, a couple of years later. After that, I got slightly disillusioned, actually, bluntly, with the academic world, because I felt that too much of the work on AI and law was devoted to interesting theoretical questions, but I wanted to get this stuff out into the marketplace. There were three things we didn't anticipate at that time, because you might be thinking, well, that's 35 years ago, why aren't there many more of these systems? Part of the answer to that's commercial. They cost a huge amount to develop, and it's not necessarily been in law firms as the leading providers of legal service interests ever to develop systems that reduce the time they spend on legal work. That sounds terribly cynical, but one of the reasons we've had such difficulties with knowledge management within law firms is because of the whole phenomenon of hourly billing, which does reward inefficiency and penalizes people who are extremely efficient. And so these technologies that make law firms more efficient, unless competitors are using them and undercutting, there's a strange behavior in the market where law firms just tend to put the techniques and technologies to one side. So the commercial imperative was not there for those who were most likely to invest in these technologies to make them a reality. But be very clear, we showed the technical feasibility in that period in the late 80s. But there were three things we didn't anticipate: the coming of the web, brute force computing, and machine learning. Now the web, again, looking at many of you in the room, you won't probably remember when the web came about. But for people like me who'd been sitting as a little isolated island of processing through the 80s on my own little machine, personal computing, that it suddenly became interpersonal computing, interorganizational computing. The idea that you could sit at your machine and have a look at stuff people elsewhere had put, or have access to services, could buy things online. It was, in the very early days, it was completely mind-boggling. And almost all of us who worked on legal AI moved after the 6th of August 1991, probably the day Tim Berners-Lee invented it. We moved on to the web, law on the web, systems that weren't nearly as sophisticated as the expert systems, the AI systems, but there was a practicality, a commerciality, a pragmatism to them, an immediacy to them. It wasn't 2 million paths you needed to craft. You could put a bit of legislation up there and some links into some explanatory notes. Not fantastic, but pretty much unbelievable to most lawyers in the 90s. And so in a way, I stepped out from AI in 1991. I chaired the third International Conference on AI and Law in Oxford, and that was just a couple of months before the web was invented. So most of us moved away from AI and the web for a couple of years. And then we learned something about brute force computing. One of the problems in the 80s was that when you create these huge decision trees, the computer systems often didn't have the processing power to navigate that massive search space that was created. And a lot of what we hoped for in certain categories of rule-based expert systems simply technically weren't feasible. But what we hadn't really cottoned onto at that stage was how rapidly processing power was advancing. And we heard a story that arrested all of us, I think. When Garry Kasparov, the world chess champion, was beaten by a computer system called Deep Blue. In the 80s, we thought that wasn't possible because we didn't have the processing power to explore sufficient number of moves ahead to outplay a great player. By the time this system was live, it could explore more than 330 million possible moves in 1 second. A good chess player apparently can juggle about 110 moves in his or her head at one moment in time. So it's very interesting as an early thought, and I'll get back to this, that the system that beat Kasparov didn't think like Kasparov. It operated in a very different way using brute force. But we got the sense then, oh my goodness, if you could apply that same technology to some of the old problems, maybe we could start developing some really interesting AI. But not that many years later came an entirely new way of thinking in the world of artificial intelligence, away from systems that are programmed to systems that learn, away from rule-based expert systems to machine learning systems. Now, when most of us who are not technologists think of the phrase machines that learn, it's terribly abstract. So I just want to give you a little example, and it's an analogy, and it's not precise, but it gives you a flavor of what I have in mind here. So imagine how I learned to speak French when I lived in Glasgow at school. The answer, in summary, was very poorly. I found it very difficult. But the mechanism was quite clear. You get given a list of words, we call them a vocabulary. You get given some rules, we call them grammar. You put the two together, and as I say, the result was not so impressive. A couple of friends of mine one summer went to Paris and came back in their oral French at least almost entirely fluent. They didn't know the rules of grammar they were following. They hadn't learned from a list of words of vocabulary. They'd watched the television, they'd hung out in cafes, they'd chatted with friends, they'd read books. And it turns out, and this is massively oversimplified, what Noam Chomsky has been going on for years, that we have this unbelievable, probably innate human ability to absorb huge amounts of linguistic data and convert that into an ability to speak a language. And it's very hard to fathom how we do that. But I don't want you to worry about how we do that. I just want you to think of the analogy that I was the first generation AI system being explicitly programmed, as it were, to learn the words, to learn the rules of grammar. The way that my friends learn French by absorbing huge amounts of data is quite similar, but it's a very, very flawed analogy for the technologists, but it's quite similar to how machine learning systems work. They absorb huge amounts of data, and they are able to discern patterns, trends, regularities in that data. They'll be able to make predictions on the basis of that data. They're able, indeed, to generate text, music, videos, images on the basis of that data. So it's much more like my friends in France. What does it mean for law? Second generation AI systems in law, there are two sorts. And I won't dwell on this just now. I'm calling them predictive and generative, but in fact, strictly speaking, they're both predictive. I just, because this is going on to YouTube, don't want people to think that I don't know the point. But in functional terms, in terms of what these systems do, they do two things. They predict and they generate. So let's have a look at each. Lex Machina, probably the best example, I think, or best known example of predictive technology in law. Developed at Stanford University, bought by LexisNexis. Many things are said of Lex Machina, but in the early days, the most dramatic was this, that it could predict the outcome of patent disputes in the United States more accurately than a patent lawyer. But here was the kicker. It knew nothing about patent law. It wasn't searching across the full text of legislation or case law. It had about 200,000 past records of patent cases, who the judge was, which law firms were involved, which individual lawyers were involved, who the parties were, the value of the claim, the nature of the claim. It turns out that if you have enough of this objective data about past cases, then in crude terms, using computational statistics, you can make a better prediction about the outcome of cases than you can by using the legal method. Now, many lawyers really get upset with this. They say this is dangerous, it has to be stopped, the system knows nothing about the law. But I go back to the question every client asks when there's a dispute coming over his or her horizon. The question, what's our chances of winning? Go back to the hole in the wall and the power drill. The power drill for the lawyer is the legal method. The client's not interested in the legal method. The client's interested in the hole in the wall, the probability. You know that old thing by Abraham Maslow, if you're a hammer, everything looks like a nail. Well, if you're a lawyer, everything looks like a legal problem. But actually, there's different ways of looking at legal problems. And if computational statistics or AI, whatever it is, can deliver a solution to a particular class of legal problem that's quicker, cheaper, more accurate, demonstrably so, you won't find any loyalty in the market to the legal method, or indeed to lawyers. So you see in microcosm there how it is that an AI system can outperform a lawyer, not by using the legal method, but by using its distinctive capabilities, its remarkable algorithms, the huge amounts of data, its mind-boggling processing power. It's not just predicting the outcome of disputes that we're seeing these predictive systems. They're being used for document review and litigation, huge piles of documents. Essentially, the systems can predict, after what's known as some training by human lawyers, they can predict the documents that a lawyer would most likely regard as the most important and relevant for a case. And pretty serious research in 2011 confirmed that a system could do document review and litigation, an AI system, machine learning system, more accurately than junior lawyers. Same in due diligence, big corporate exercise, buying a big company, reviewing all its contractual material. Again, these systems can predict those documents, those contracts, those agreements, in fact, those clauses that would cause the gravest concern to lawyers. And also these systems can predict the outcome of deals. So that's the predictive AI systems. More recently has come in the scene, and for most people was a completely new thing, the idea of generative AI. We learned about it, most of us, in November 2022. And this of itself is quite alerting, just how quickly it's become, within a very small period of time, 100 million users, outstripping the adoption of any new technology. It hit home to me how remarkable the system is in relation, and this is a minor advert, I concede, but in relation to my new book, the third edition of Tomorrow's Lawyers. In an early piece of marketing this book on social media, LinkedIn and Twitter, I said my book's coming out at a particular date, and I included an image. The most common response was, why are there flames at the bottom of your book? So I thought, why don't I run a competition online, create a little bit more noise about the book, and ask people why they think I had that, and the answers that were closest to my real reason, I'd give them. My joke was first prize 1 book, second prize 2 books, which I thought was hysterical. I don't think anyone else found amusing. So that was what I put out on social media. Here's the big competition. This German guy writes back on LinkedIn. He said, I asked GPT the following, ChatGPT the following. Richard Susskind publishes the 3rd edition of his book, Tomorrow's Lawyers. There's paper and flames on the cover. He keeps getting asked the significance of the flames on the front cover. What do you think? Write a short, creative answer. Here's the answer. And this is what boggled my mind. This is a computer system. And remember, this, of course, has been replaced by a system that's considered to be 8 times better in the crudest terms. The flames on the cover of Richard Susskind's book, Tomorrow's Lawyers, likely represent the transformation and upheaval that the legal profession is undergoing. As the world becomes increasingly digitized and technology continues to advance, the way that lawyers do their jobs is changing. The flames may symbolize the change and the challenges that come with it. They could also represent the potential for new opportunities and growth as the legal field adapts to these changes. Ultimately, the significance of the flames on the cover is up to interpretation, but they undoubtedly represent the complex and shifting landscapes of the legal profession. I mean, it's just breathtaking. One minor grammatical mistake, I gave it first prize. It was better than any of the submissions I had from students, from lawyers, from judges, from in-house counsel. And that's a computer system that's now been superseded. So here's what I want to say to you about ChatGPT. For my money, and this is a personal view, it's the most remarkable development that I've seen in 40 years of AI. Secondly, unpopular one for computer scientists. Most computer scientists weren't expecting this. The narrative of most computer scientists over the last decade or so is, and it's not all, but most or many, don't worry about AI for now. It can only operate in narrow domains. You saw it everywhere. Every computer scientist, or sorry, I have to be more accurate, most computer scientists were saying it will only operate in narrow AI. They were making a false distinction between narrow AI and what's called, well, you know, the AGI, or the idea of the computer system that has the intelligence of the human being. They were saying until it has this general purpose intelligence, there's a huge gap. But what this has shown is the system doesn't need to have our intelligence to operate at an incredibly high level. These systems don't operate like us. And so the mistake was made. They thought, unless you have systems that can think like and reason like a human being, they'll only work in a narrow area. And that is proven to be wrong. The chat is a lot better than expected. You know, it mimics human conversation. And I think it really does do to a remarkable degree. I find myself saying a lot of please and thank you when I'm interacting with it. I also find myself slightly apologizing when I'm asking it to do something again and again. And I don't joke about that. I think it's an interesting reaction. It does feel fairly human-like. It's massively demonstrable, which is a huge thing in the legal market. You can just say to them, I'm going to sign up, log on, and after 5 minutes, you will be amazed. But the biggest point is this. Its significance lies not in what it is today, but in what these systems are likely to become. We already have GPT-4, but what will GPT-12 look like when these systems are already outperforming us in many tasks? I stress again, we're just at the foothills. So we don't need AGI. We don't need artificial general intelligence for these systems to perform at a high level. So I want to try and contrast two reactions in bringing some of this into focus. Henry Kissinger and others in the New York Times, probably about 6 weeks ago, I think, said this, that AI, he was talking about ChatGPT, will redefine human knowledge, accelerate changes in the fabric of our reality, and reorganize politics and society. It will open revolutionary avenues for human reason and new horizons for consolidated knowledge. One of the great iconoclasts, one of the great intellectuals of the 20th century. Here's another one, Noam Chomsky. What does Chomsky say? With others, he writes in the Wall Street Journal, it is at once comic and tragic that so much money and attention should be concentrated on so little a thing. Given the immorality, faux science, and linguistic incompetence of these systems, we can only laugh or cry at their popularity. Isn't this amazing that this thing called ChatGPT comes out, and two of the, you may not like them, but two of the great minds of the 20th century have such diametrically opposed views? Well, this is an interesting thing about AI, that we're often talking past one another. Some are talking architecturally. They're interested in the nature of intelligence and how the human brain works. They're interested in neurophysiology. They're interested in using models from the mind and emulating them, for example, in neural nets. They're interested in the structure of the software, of the algorithms. They're interested in the architecture. And that's very much Chomsky. Chomsky's saying, it's mildly interesting, but it doesn't come near to explaining the language acquisition capabilities of the human brain. The functional people like me are thinking, oh my goodness, our health systems, our education systems, our legal systems are creaking. Surely here's a key to solving some of the major world problems. These systems are becoming increasingly capable. So they're actually just talking past one another. But one of the dangers is that a lot of the people who talked architecturally, who talked about AGI, who thought that the only way a system could perform at a high level was by somehow having the intelligence of a human being, that was dangerous because they missed the emergence of a new set of technologies that operate at a remarkably high level. So the legal task ChatGPT can take on, already summarizing, drafting and analyzing contracts, producing skeleton arguments, conducting legal research, undertaking document review, comparing treaties and statutes, helping general counsel without needing to go to external firms, supporting judges. A Colombian judge used it recently and said so in his judgment in preparation for its decision. And this is just the beginning. But hang on a second. I think I reason, this is a lawyer speaking, a computer system can't actually think. But what I do as a lawyer requires thinking, so I'm safe. A computer system can never do what I do. And that's to commit what my son Daniel and I in our book, The Future of the Professions, call the AI fallacy. It's the mistaken assumption that the only way you can develop systems that perform at the level of experts or higher is somehow to replicate the thinking processes of human specialists. This, I'm afraid, is the folly often of the architecturalists. They are looking too limited a way at what it is that AI will achieve. No one thinks this is a good idea. No one thinks the way to get an autonomous vehicle is to take a regular car and put a robot in the seat. Autonomous vehicles are not driven by humanoids, they're driven by data. It's an entire reconceptualization of the thing that gets you from A to B. But what about judgment? The lawyer often say to me, that's what my clients want, they want my judgment. How can a machine ever exercise judgment? And I say that's the wrong question. You should be asking actually a different question and thinking about this. To what problem is judgment the solution? That's to say, why is it that people come to us for our judgment as lawyers? We'll be very clear. I don't think in many law offices a client comes in and says, good morning, I'd like some judgment, please. Judgment is a faculty, it's a facility, it's an ability that we have as human beings. It's part of our toolkit, and we use it to handle problems of uncertainty. When a client comes to us, they're in circumstances, they don't have the knowledge to classify or categorize it from an expert point of view, nor do they have the expertise to know what to do next. So they often say, in your judgment, what should we do? But the fundamental problem here is not a search for judgment, it's how to solve uncertainty. Hole-in-the-wall power drill issue again. The question isn't, can a computer system exercise judgment? The question is, can a computer system handle uncertainty? And it's pretty clear from machine learning that that's what machines are very good at doing, from huge amounts of of often unanalyzed data, bringing certainty. What does it mean for jobs? Who are these people? Well, these are the people who are designing the systems that will be solving clients' legal problems in the future. These are the people who will be designing the systems that will replace many lawyers in the future. Controversially, I call them tomorrow's lawyers. I'm less keen to define lawyers in terms of their education and indenture. I'm more keen to say that those people who contribute to the helping of clients or citizens or whoever with their legal problems, we can call them tomorrow's lawyers. It's a piece of rhetoric, but you'll get my point. But it leads me to say the next decade is not a decade of unemployment for lawyers, it's redeployment, because lawyers need to become these people. Because the question of the 2020s for all lawyers is this: do you compete with these emerging systems or do you build them? By competing, you're saying, I hear what Richard says, he doesn't understand the work I do really. No computer will ever be able to do the work I do, I'm pretty safe. And in so doing, I'm saying you're competing with these emerging systems. As these systems become increasingly capable, that's a fight you're unlikely to win. But the other option, it's not just a question of your career, it's also a question of your strategy for your business, if you're a law firm, or indeed if you're a law school, is to say, and in fact I think this is an obligation in lawyers, is to say we need to build the systems that replace our old ways of working. And that's my mantra really. That's, I think, the job for all of us. And frankly, it's not just in law, it's in medicine and it's elsewhere. That's the challenge of our generation. I say we've been born at a time of greater and more rapid technological advance than humanity's ever witnessed. What's expected of us, that's expected of us. So let me in conclusion say a little bit about the future. And I do so with some hesitation. 25 years ago, when I wrote my book, The Future of Law, I was pretty confident about how the future would unfold. And it's not for me to mark my own homework, but I think by and large I wasn't far off, maybe 5 or 10 years off, but not significantly off. There's every chance that technologies over the next 25 years will develop that they're inconceivable today. It's not that you just can't see how a system could do this. It's that their very function and nature and impact is inconceivable. I think the pace of change is so considerable that this is a very difficult question to answer. I just want to say under 6 headings, and I'm conscious of time, but we'll run just over the hour. A little bit AI generally, then some general worries, a little bit AI in law, and some concerns, some opportunities, and I want to finish on neurosurgeons. On AI, here's what I think. Our systems are becoming increasingly capable. They're doing so at an accelerating pace. In terms of the exponential curve, we're at the knee of the curve, which means we're about to experience quite unprecedented acceleration in the impact. These systems, in almost all respects, I think, will be more capable than us. And I'm talking in terms of the things we do using what we call our intelligence. I think we're going to have to come to terms with sharing the planet with machines that are wildly more capable than us. It'll redefine what it is to be human. It'll redefine what it is to work. it'll redefine for many of us what the meaning of life is. And I think we'll enter an era of transhumanism, where in 50 years' time, I doubt our ancestors won't be digitally enhanced. This technology will be embedded within us, robotically in terms of prosthetics, and I suspect even chips embedded in us, nanobots roaming around us. It probably is the next stage of evolution of the human being. So that's pretty big stuff. What are the general worries? That some of this stuff gets in the wrong hands, that there'll be unintended outcomes. We're already seeing this. The possibility of autonomous self-replicating systems sounds like science fiction, but it's imaginable today. A more local or short-term issue, the remarkable concentration of power. The power and wealth that's concentrated in the very few companies around the world that actually own them and deliver these systems is scary. They're more powerful than many nation states, and they're largely unregulated. And we're not really thinking clearly about the ethical boundaries. We're by and large thinking about the ethical boundaries of existing and emerging systems. We need to think about the more advanced systems of the sort I'm hinting at. Can machines think is a question, or will they be able to think, that people still ask. There was in 2011 a remarkable experiment when IBM again developed a system called Watson and appeared in a TV quiz show called Jeopardy in the United States. On a live episode of Jeopardy, Watson, bear in mind 12 years ago, beat the two best ever human Jeopardy champions. Remarkable performance. But that's not what I want to discuss. I want to discuss what John Searle said. John Searle, philosophy professor at Berkeley, said the next day in the Wall Street Journal. He said, Watson doesn't know that it won in Jeopardy. Now, isn't that perfect? Watson didn't want to phone up its mum to say how excited it was. It didn't want to go down to the pub to celebrate, because Watson was not a self-aware conscious entity. And for Searle, who's argued against what he calls strong AI, systems that actually are conscious and think for many years, I think he probably thought that was the joke to end all AI jokes, and it is a good one. Well, by AI terms, it's a good one. But the truth is, we just don't understand AI systems of great complexity. And I'm at least open to the idea when AI systems of a certain complexity, some kind of, I don't want to call it consciousness, because that's a human attribute, but some kind of sentience might come about. Indeed, it may well be that for us as we evolved, that consciousness simply arised. It's a function of complexity. AI and law, it won't be an overnight change. There'll be an incremental transformation. But folks, it's going to go way beyond automation. This idea of lawyers thinking, what in 20 years' time or 25 or 50 years' time will our firms be doing? I think it's unrealistic to think we'll be doing almost all of what we're doing today. Legal businesses will not be the old law firms. These systems will be superior in the great majority of legal tasks that lawyers do today in the next 25 years. I believe lawyers will fade like craftsmen. Think of mercers, think of cordwainers, think of wheelwrights, think of tallow chandlers. I know you think about them a lot, but they produced silk, they produced shoes, they produced wheels, they produced leather goods and candles. But the interesting thing there is that our market globally for all these things has massively increased since these people were in existence in the era of the trade. But we found different methods of manufacturing, of distributing, different methods of marketing too. And it's not that that outcome is no longer needed, it's just we no longer need the producer. I think the same will happen. I think people will look back, maybe not in 25 years, but 50 or 100 years and say, solicitors in England, what on earth did these people used to do? Sounds a bit like cordwainers. AI will go way beyond what economists talk about task substitution. If you look at most of the research done by the big consulting and banks just now, they're looking at what tasks the humans being the machines will do, and they're swapping in and out. But we'll just find entirely different new ways of solving problems. We'll do risk control. So for example, it's entirely conceivable, there's early signs of this already, a big organization will have little systems searching across all its data to identify early signs of a compliance breach, of an exposure to liability, perhaps a contractual difficulty. All of that will be done automated. Compliance will be built in. just as when you drive a little golf buggy in a golf course, it stops at a particular moment, compliance is built in. Or when you use your handheld game, solitaire, or you may call it patience, you can't put a red 5 under a red 6 because the rules are embedded in the system. Much of the law that's created in the future will be immediately embedded in our buildings, in our working processes, in our lives. You know about the Internet of Things in everyday objects. So somehow thinking that this is about automating lawyers is manifestly, in my view, naive. We also challenge fundamental legal institutions. In some early thinking about this, I'm not sure the institution of contract, for example, will survive the next 50 years. Contract is a way of bringing predictability and certainty in our world, but it's already creaking at the edges. All of us have clicked probably 200 or 300 times contracts that subject us to hundreds of pages of obligations with no insight or knowledge or involvement in any of them. We may, in an era of these incredibly able machines, find entirely new ways of bringing the certainty and the predictability and the trust that the contract brings. We don't contract now in a print-based society as we did in a primitive society, and as we shift into a fully AI-based society, we won't do so again. Penultimately, the concerns of all of this in law, first of all, the rule of law most fundamentally. None of what I say today would I want to prejudice fundamental ideas like those who govern should be subject to the same laws as those who are governed, that we have an independent judiciary. And for some people, and I'm one of them, who believe the rule of law should mean that our law is clearly articulated and available. There are many other aspects to it, but I think we can maintain principles of rule of law, or I hope we can, even in the face of these systems. They should be built to comply with the rule of law. You may think I was repeating myself there, but I have two concerns about justice. One, that, for example, in the whole idea of AI in the courtroom, people will say this is an affront to justice, which is essentially human and it needs to be face-to-face. And there are all sorts of fair trial issues that require justice to be met in the traditional way, and I accept the arguments. But I have a different fear, and that's the fear about distributive justice, that dispute resolution should be a social good that's available and widely available to all as a matter of distributive justice. And it worries me that we actually are seeing the emergence of systems that could overcome the access to justice problem, but they might be struck down on grounds of other principles of justice. And in my book, Online Courts of the Future of Justice, I say we've got 7 principles of justice that are at war with one another, pulling in different directions. I don't think one necessarily trumps the other. I do worry as a generality, both with ethics and in regulation of AI, that we move too quickly to solve the problem of today's technology. I think we need to be doing more longer-term thinking. Let me finish about neurosurgeons. You may wonder why that's relevant, or if this is the first slide for my next talk. But in fact, this is me coming towards an end. I was invited in 2017 to give a talk about the book, The Future of the Professions, to 2,000 neurosurgeons. Scary audience. And they asked me to be controversial and answer the question, what's the future for neurosurgeons? And my opening line was this. I said, patients don't want neurosurgeons. Gasping audience. I said, patients want health. I said, for a particular type of health problem, you're the best answer we have today, and thank goodness for you. But do you not think in maybe 25, 50 years' time, people will look back and think and say, it's unbelievable we used to cut bodies open? Because I said that day, the future of healthcare, in my view, is not just better surgery, or indeed robotic surgery. In the long run, it's non-invasive therapy and preventative medicine. And you can run similar arguments in law about preventative lawyering. But the bigger point that occurred to me that day was this, that the question, what is the future of neurosurgeons, is the wrong question. The question we should be asking is, how in the future will we solve the problems to which neurosurgeons are our current best answer? And the same goes for law. To ask the question, what is the future of lawyers, is to ask the wrong question. The question you should be asking is how in the future will we solve the problems to which lawyers are our current best answer? And my answer to that question today, and I suspect for the rest of my days, will be AI. Thank you very much. Now, I believe there's an opportunity. I'm more than happy to moderate it myself for some questions. So you can ask a question. Perhaps it would certainly help me, but help the rest of the audience if you say who you are and what your interest is. Alain, one of the few people I know in the audience.
Yeah. we were together in Belgium 200 years ago.
His supervisor was my moral tutor, Joseph Raz.
Yeah. I think you touched upon my concern almost at the end. And my concern is that while I may agree that AI may provide better decisions, perhaps, or even already provides better decisions with respect to many legal questions, there is a value in thinking about legal questions, and there is a value in participating in engaging in them. So I think about, I thought about in the context of criminal law in a different context. We think about revenge, we think about mercy, we think about all of these aspects, all of these normative aspects that are essential part of the discourse, moral discourse, political discourse, legal discourse. And the legal discourse serves, I think, a very pivotal role in constructing these elements. So I think that, and the most important thing, we think about them, and I think this is more difficult to justify, but I think we think about them with respect to particular questions. We want to see how rules apply to a particular case. I think that a large delegation of powers to AI will undermine this kind of participatory discourse, normative discourse. And this will, may have undesirable effects. Beyond the claim that perhaps it is intrinsically valuable to engage in these things, it is also important because these talks or this conversation, this discourse, is very crucial in other aspects of our life, other dimensions, in the interpersonal dimensions and so on and so on. So I think, anyhow.
It's a great question. And I'm going to summarize it because I've been asked to do so for the YouTube version, which may not pick up the question. So first of all, I'm going to do a great injustice by summarizing your question. But what you're saying is, I think, in using AI, for example, in judicial decision making, we are losing something that is fundamental to the judicial process and to society, the discourse and debate, the exploration of the concepts, the exploration of the arguments, the development of the rules, and so forth. So, as you know, I'm alive to the thought. I've got a couple of pragmatic and then a more theoretical observation. My pragmatic thought is if I'm a policymaker, taking my advisor to policymaker hat on and taking my jurisprudence hat off, I'd say if I go to Brazil and there's 80 million cases in the backlog of their court system, I'd say the social priority here is to find a cheaper and cheerful way of resolving disputes that is good enough. And for many categories of disputes, the pragmatic argument is good enough. Good enough is good enough. My second argument is, for now at least, I'm certainly not suggesting that all cases should be handled in this way. And indeed, I think there would be merit in having the hardest cases still heard and discussed and debated and published in the way you're suggesting for the very reasons you are suggesting. I will make one observation, however, that it's not quite, but it's almost random what legal problems actually reach our courts, and indeed what legal problems are even reported. And so I get that point, but we also have to say it rests on a rather random process for deciding cases and selecting cases. Third point, more theoretical, and something I'd love to discuss with you at greater length is, I can conceive of machine learning systems, specialist machine learning systems, whose output is based on the very discourse you're recommending, but not generated through the process of judicial decision making. I can conceive of public discourse, far more extensive, far richer, far wider, far more consultative, far deeper, that could be captured and then fed as data into these systems. So it's not the narrow views of, say, in England, by and large still, I'm afraid, white guys in their 60s, or indeed in the academy. It's a far richer and wider range of discourse. And what fascinates me is the possibility, is the arguments, the propositions, the conclusions, even if not for decision making, just of intrinsic value that will arise when we join with our machines in having this kind of debate. But I can see a world, I think it's conceivable, it's not inconceivable, I can see a world where these systems will themselves apparently generate a richness, a subtlety of argument that outstrips human beings. I don't say that immediately, but it's conceivable. You might wonder what's inconceivable. Edward de Bono once said to me, when I asked him that question, he said, from the earliest years, it was at least conceivable that a human being could stand on the moon. What was inconceivable until the 20th century was that 1 billion people would watch this on a little box in their lounge called the television. And that's a great, I think, illustration of there's much out there that's inconceivable. My plea is that this is the kind of issue we should be discussing in modern jurisprudence. Thank you. Sir.
Thank you. Lovely talk. My name is David. I come from the philosophical side. I know nothing of AI.
Welcome.
There's a distinction often drawn in another context, also by chosen for us, that I think may be helpful here. So we can distinguish between decisions in which the only thing we care about is that we make the right decision, and decisions in which that's not the case. We care about who makes the decision, or we care about how the decision is made, and sometimes we're even willing to pay a price.
Yes.
In say the likelihood of how good the decision is, or just how good it will be, in order to make sure that these decisions are made by the right person or something like this. So an example that is often given is even if someone else is better at choosing a life partner, a romantic life partner, in terms of whatever, however you want to define success, it still seems that that's a decision I should be making. Maybe not if they're extremely better. Maybe there's an upper bound, but still, and we're willing to pay a price for that. And say how likely is the relationship. So I'm thinking maybe an analogous distinction can be helpful here. Namely, when it comes to neurosurgery, I just want the decision to be yours. I don't give a damn about anything else. I don't give a damn about bedside manners. I just want the right decision. If AI is even just minutely better than the best neurosurgeons, I know who I go to, right? But maybe AI for choosing romantic partners is a little trickier, although I know that there are some events as well. And then the question becomes whether living decisions are more like this or more like that, or maybe some of them are more like this and some of them.
It's a great distinction. Again, I'll do a bad job of summarizing it, but saying for some decisions it's not just the outcome, the way in which the outcome is achieved is sometimes of intrinsic value itself. And the answer is I agree with that and agonize over this. You remember I was talking about the 7 conceptions of justice, and to some extent that overlaps with the substantive justice. We want our outcomes to be fair, and procedural justice, where the equivalent, as people would say, it's actually, from the point of view of the rule of law and for society, it's not just enough that the decisions are fair. There has to be procedural justice. There has to be the day in court, for example, or the fair hearing, which has to be face-to-face, is they would say, intrinsically important. I actually think that through further scrutiny, that particular argument, not Joe Raz's, but that one collapses. But I don't want to reject the idea that some decision making, that how the decision is made is intrinsically important and not just important for its outcome. Putting my policymaker hat on, or advisor to policymaker, I'd say you'd have to make a really compelling argument when I've got 80 million cases in my backlog in Brazil. But the distinction is terribly important. And again, this is the kind of debate and discussion we have to be having. What is it that, and I talk about this a lot in my book on online courts, what is it that is worth preserving for its own sake? So I don't think, for example, and I know you're not suggesting, I don't think wigs on judges' heads, although for some people they would regard it as a vital part of the process. For me, solemnity might be important, but it's not. The wig is one way of delivering that. So I want this deeper thinking, not what are the surface features. Because I asked the question, is court a service or a place? Do we really need physically to congregate together to resolve our differences? And for many people, they would say, no, you're misunderstanding. The court is of itself symbolic of the rule of law. It's intrinsically important. And I want to challenge that, because I say a court service that's available as it is today to a tiny minority of people and unaffordable to the rest is like having a Rolls Royce for one and everyone else is walking. And so I want to know what intrinsic benefits of traditional process trump distributive justice. And that's what I'm open to that. And conceptually I'm open. I just say in the book, I'm just not sure where they are yet. But the distinction is vital. Thank you.
So hi, my name is Einat. I'm also a faculty member here. And I have actually two questions. The first is that it seems from your talk that your basic assumption when you talk about AI is that its development is mainly related to technological development. So people from the AI field will develop the technology as far as it goes. But this doesn't take into consideration, for example, the role of regulation in shaping AI. And we know now that there's a lot of regulation out there that is trying to shape AI in particular directions, for example, considering human rights, etc. So where do you think that regulation should take AI? And given that AI can be bound, limited, regulated in particular directions, not only by market forces or technological developments, how does this work together with your argument? The second point.
Can I take one at a time, because I'm conscious that this is being video. So the first question, the challenge to me was that I was assuming you challenged that AI is largely a technological matter in its development. I hope I hadn't given that sense. I think as a matter of empirical fact, that's how it's been so far. But I and others for many years have argued that AI is far too important to be left to AI scientists. This, as I hope I've given a hint of, is fundamental to the future of society, our culture, our humanity. And anyone who read Joseph Weizenbaum's book, Computer Powered and Human Reason, in the late 70s was completely alive to the and I did, and I thought it was wonderful, I still do, completely alive to the challenge you're making. An AI scientist from MIT who developed a system called ELIZA, which mimicked a form of psychotherapy, Rogerian psychotherapy, which essentially feeds back your words at you. He asked the secretary to have a go at it. She used it for a second, then asked him to leave the room. And that caused him to write a book, because he thought these developments in technology go deep to the heart of what we are as human beings. So if I give any sense that I thought we can leave this to the AI scientists, I think completely the reverse. As my son Jamie in one of his books says, the reality is that these software engineers are now really social engineers, and where in the social engineer, the software engineer's training is ethics, is regulation, and so forth. And so I think in the first instance we have some deep thinking to be doing about even something's technological possible. Do we think it's desirable? And even those things we desirable, how is it we contain them? All of these issues, I think the quality of ethical debate is limited to some extent just now. And this is not criticism because it's well-meaning, but we haven't had enough philosophers involved. It's a bit like the thinking about medical ethics in the 70s, where medical ethics was often a well-regarded doctor giving a view on what he thought was right or wrong. That was regarded as medical ethics, and then a whole bunch of philosophers said, no, there's some very deep thinking to be done here about the nature of human beings, of personality, of health, and so forth. And what I wish is that more of the ethical discourse was actually done I don't think it's that much to ask by people who are experienced and knowledgeable ethics. It's well-meaning, but it's visceral moralizing is what we've got just now often, rather than serious philosophical analysis. The regulation is harder. I hinted at this earlier. One of my worries is, and of course we need to regulate in a whole bundle of ways. One of my immediate concerns I mentioned is the concentration of power in unregulated companies that are delivering this technology that's changing our lives. And of course, I believe there's scope globally for intervention there. More particularly when you look at generative AI and people are rushing to put together rules and regulations, I wonder if it's premature. I think we need time to think through and to test. This technology is really, of course, large language models and neural nets and so forth have been around for ages. But the public's awareness of, and therefore politicians' concern about, ChatGPT and generative AI is about 4 months old, or about 6 months old now. It's early days. And I'm hesitant about rushing to regulating too early. And again, this is what I think, great contribution from law schools. We need to be thinking deeply, not just about whether or not regulation and constraint and control is appropriate, but the nature of that regulation, and perhaps above all, how at a time where technologies are advancing at this ferocious rate, how we have the mechanisms to update and change our regulations. So my thinking is we need to be, and it mirrors something that was said elsewhere, we need to be more principle-based in our thinking of regulation before we get down into the weeds of the rules. But please don't for a second think that I either think that these technologies should be driven only by AI scientists, or that I think it should be unconstrained. Next question.
So my name is Daphne Lewinson, also faculty of law. And I wanted maybe to continue David's point, but in a to give a legal example, because I wonder about the future and the limits. I won't be here, but still I'm curious to know your thoughts. Because what I think that we should fear, not only like today that ChatGPT makes a lot of errors, but when we reach the stage when it's too perfect for our good. And the example I was thinking of was Philip Dick's Minority Report. I mean, the possibility that seems not science fiction at all, that I could be arrested before I commit a crime and before I even know that I'm going to commit a crime, because all the data would point out that I am going to murder in the next week someone. And would we want this kind of a future for ourselves? This is a legal context. And I feel that on some basic point, but maybe I'm old-fashioned, that we want to be judged, convicted, punished by people who are as flawed and as imperfect as we are. And there's something not fair about this type of minority report. So I wanted to know what you think about it.
In terms of being judged by another human being, judges advance that argument a lot, and so do lawyers, and so do I sometimes too. I think we have to be alive to, and it's often very hard for us as lawyers or legal academics, alive to how it is that other people view the judicial process. And so we have to put ourselves in the shoes of non-lawyers thinking whether or not they want to be judged in an era, say 20 years' time, where machines are remarkably advanced. And while our current instincts, and I may share your instinct, that I would like to be tried by a judge, it may well be the same actually as the surgeon point, that we might get to the stage where I'd feel more confident in a system than a human judge, in which case that might trump the feeling I share with you. You know, I've been in the law as you have for decades, that somehow there's something intrinsically human about the judging process. I try to, when I'm thinking about these things, just put these to one side and say, put myself in the shoes of the recipient 20 years hence. I'm not sure we'd come to the right answer. The Minority Report one is fascinating, isn't it? And I think all of us should share the instinct, the idea of being convicted before you've even thought of committing a crime is a scary one indeed. But there's no but about it, that's scary full stop. I think this takes us into the era of the inconceivable. I think the technology is going to throw up problems of this sort, where the systems will, in predictive terms, for example, be able to foresee contingencies that are well beyond our contemplation, but a remarkable degree of accuracy. And it becomes a little bit of a free will determinism thing that if you're a determinist and you believe everything we do is predetermined anyway, conceptually as a philosophical exercise, you can imagine the machine that actually can follow all the paths in which determinism takes us. It's a very, very disconcerting future. If you're asking me, do I personally like the idea of machines playing a central role in convicting people before they've even had a criminal thought? My answer, of course, is no. Do I think we are going to have to think through the ethical and principled implications of systems that are wildly more capable than us, and therefore capable of identifying flaws, problems, difficulties, shortcomings, yes, potentially crimes, but maybe weaker issues, defaults in debts and so forth? Do I think we're going to have to think this through? Yes, we are, and we'll probably be using our machines to help us think them through. Thank you very much for listening.